Pistol stabilizing braces, they're popular. Millions of people have them, but soon federal regulations are changing.
Decision is affecting millions of people who might not even know that they're crossing the law.
It's pretty obvious you're misleading people here when you say that the braces changed, because your rule affects the braces that didn't change.
On day one, back in 2012, if they'd looked at that submitted product and go, yeah, that's a stock, we wouldn't be having this conversation.
The pistol brace rule is dead. Vacated, gone. Everyone's celebrating. But here's what nobody's talking about right now. The ATF just revealed in court documents that they might not actually need that rule to come after brace owners again. And what they said should have every single gun owner paying very close attention. So here's the situation we're dealing with right now. The Trump administration dropped the Biden-era pistol brace rule. Courts have dismissed multiple lawsuits because, technically, the rule doesn't exist anymore. Victory, right? Case closed? Well, not exactly, because buried in recent court filings, the Department of Justice made a statement that changes everything about how we should be viewing this entire situation. They essentially said that while the rule is gone, the legal theory behind it, the interpretation that braced pistols could be classified as short-barreled rifles under the National Firearms Act, that interpretation is still very much alive. And here's the kicker. They're arguing that no court has the authority to stop them from using that interpretation whenever they want. Now, if you're thinking, wait, that sounds like they're keeping a back door open, you're absolutely right. And that's exactly why one major lawsuit is still fighting, even after everyone else has packed up and gone home. Let me bring you up to speed on how we got here, because the timeline matters for understanding why this remaining case is so critical. The Biden administration's pistol brace rule claimed that most brace pistols were actually short-barreled rifles under the NFA. This wasn't just some minor regulatory tweak. It potentially turned millions of law-abiding gun owners into felons overnight unless they registered their firearms, destroyed them, or removed the braces. Multiple organizations filed lawsuits challenging this rule. The big breakthrough came when a federal judge in the Northern District of Texas struck down the rule entirely and issued a nationwide vacature. That means the rule was thrown out across the entire country, not just for the specific plaintiffs in that case. The Biden DOJ appealed that ruling, but then the administration changed. The Trump DOJ came in, looked at the situation, and decided to drop the appeal. They conceded the case. The pistol brace rule was officially dead. At that point, most of the remaining lawsuits were dismissed as moot. The courts basically said, well, the rule doesn't exist anymore, so there's nothing left to fight about. One of the last remaining cases, filed by a major Second Amendment organization in Texas, was just formally dismissed with prejudice. That case is now completely over. But here's where things get really interesting. There's still one major lawsuit standing, and it's taking a completely different approach than all the others. This case isn't just asking the court to acknowledge that the old rule is gone, it's asking for something much more significant, a permanent injunction that would block the ATF from enforcing its underlying legal theory going forward. See, here's what everyone needs to understand. The previous cases struck down the rule itself, but they did it on procedural grounds. They said the ATF didn't follow proper rulemaking procedures or that the rule exceeded their authority. What they didn't do was reject the ATF's fundamental interpretation of the law, the idea that braced pistols can be treated as short-barreled rifles based purely on the statutory text of the NFA. That interpretation is still sitting there, untouched, like a loaded weapon in the ATF's arsenal. And this remaining lawsuit is trying to take that weapon away permanently.
So we've got a major new development in the nationwide fight against the ATF's pistol brace rule.
Oh boy. Breaking news. The ATF brace rule is dead.
As some of you may have heard late last week, the pistol brace rule has officially come to an end, not a moment too soon.
They are saying that the stabilizing brace being on your gun, assuming that or believing that makes it automatically an SBR, is overbroad.
This isn't a rifle, this is a pistol with a stabilizing brace, right? So that's gonna be the arguments.
Your pistol brace is legal once again. Another court victory thanks to a Texas-Wisconsin tag team.
Now, the Trump DOJ just filed a motion to dismiss this case, and what they said in that motion should raise serious red flags for anyone who cares about the long-term security of pistol brace ownership. Their argument goes like this: the court cannot enjoin the ATF from enforcing legal theories. Courts can only block final agency rules. Since the pistol brace rule no longer exists, they claim the court has no authority to stop the ATF's interpretation that braced pistols are short-barreled rifles. Read that again carefully. They're not saying we don't believe braced pistols are SBRs. They're not saying we'll never try to regulate them again. They're simply saying you can't stop us from holding this view and potentially using it later.
Now you all can go back to putting all the sweet SB tactical braces on your AR and AK pistols without worrying if you're breaking the law.
But in the very last remaining pistol brace challenge, one of the big ones, something troubling has now happened.
It's going to get there. There's too many people. There's too many risks. There's too many legal issues.
And this has been litigated in many courts over the last 3 years, different districts and different levels, and all have come back with the same conclusion.
Now, another major pistol brace lawsuit has also been dismissed by a court.
To redefine what a short barrel rifle is, shockingly, is not ATF's job. It belongs to Congress.
That silence speaks volumes. What they didn't say is just as important as what they did say. They never committed to abandoning the legal theory. They never promised that future enforcement wouldn't happen. They just argued that the court's hands are tied. The plaintiffs in this remaining case warned the court about exactly this scenario. They explained that without a permanent injunction, the ATF could drop the formal rule, which they did, and then enforce the same restrictions by relying purely on the statutory definition in the NFA. Think about what that means practically. A future administration wouldn't even need to go through the rulemaking process. They wouldn't need to publish a proposed rule, take public comments, or justify their reasoning. They could simply start enforcing their interpretation of the existing statute through selective prosecution. One gun owner gets charged, then another, then another. No new rule required, just the ATF's legal theory that braced pistols have always been short-barreled rifles under the text of the law. The previous case that struck down the rule only addressed the procedural problems with how the rule was created. It didn't touch the substantive question of whether the ATF's interpretation of the NFA is actually correct. That leaves the door wide open for future administrations to walk right through.
That rule essentially claimed that most braced pistols were actually short-barreled rifles under the NFA.
Making pistol braces illegal or declaring that your pistol brace equipped pistol is a short-barreled rifle, that's gone.
Doing what government agencies do when they can't win by playing by the rules, they just flip the board over and don't play by the rules.
The Fifth Circuit had already vacated this rule, and the Department of Justice was kicking around appealing it.
Most of the remaining pistol brace lawsuits were dismissed as moot because the ATF agreed that the rule was no longer in existence.
Is this going to be going up in a criminal procedure mindset, or is this going to be going up in administrative and purely constitutional test?
What we're witnessing right now is a sophisticated legal chess match. The DOJ's main arguments for dismissal are straightforward on the surface. There's no current rule on braced pistols, there's no final agency action anymore, and therefore the court has no jurisdiction to issue an injunction against their legal theories. It sounds reasonable if you don't think about it too hard, but the plaintiffs are making a compelling counter-argument. They're saying that the threat of future enforcement is real and concrete, not hypothetical. The ATF has demonstrated through their own court filings that they still hold this legal view. The only thing stopping them from acting on it is political will, not legal constraint. And political will changes with every election. Every 4 years, the entire calculus could shift. A new administration could decide that pistol brace enforcement is back on the menu, and they'd have all the legal justification they need already sitting there, pre-packaged and ready to go.
One big lawsuit left, challenging the pistol brace rule and this interpretation of brace pistols as SBRs under the NFA.
Stabilizing braces essentially don't make a gun a short barrel rifle, and the fact that the ATF's rule was thrown out by a court.
And the way it stands here, we at the USCCA believe this is an overreach of the ATF's authority.
You can buy all the AR and AK pistols you want and put whatever brace you want on them, and you don't have to register them with the ATF.
Legal theory was used to put in place the actual rule itself, but the legal theory has not been struck down by any of these cases.
This, of course, will bring an end to one of the saddest chapters in the history of the ATF.
This case represents something larger than just pistol braces. It's about whether federal agencies can maintain threatening legal interpretations indefinitely, holding them over citizens' heads like a sword of Damocles, while technically not having any active rule on the books. If the court dismisses this case, it sets a precedent. Agencies could create rules, get them struck down, and then simply revert to claiming their interpretation of the underlying statute gives them the same power. The rule becomes unnecessary. The threat remains. If the plaintiffs win, it establishes that courts can and should block agency interpretations that threaten constitutional rights, even when those interpretations aren't currently being enforced through a formal rule. It closes the back door permanently.
They are not denying that they hold that legal view at all. They are only saying that the court cannot stop them from using it.
If you were one of those poor souls that registered your gun during the 120-day period, those guns are now officially considered SBRs.
As you recall, the pistol brace had always been okayed by the ATF, had always been considered not to be a short barrel rifle.
They shouldn't be making this rule, but it's out there. And people should be aware of it.
The rule is dead, throw this case out, but you cannot touch any underlying legal theories that we have because that's not at issue in this case.
So let's break down exactly where things stand right now. The formal pistol brace rule has been vacated nationwide. That's done. Multiple lawsuits have been dismissed as moot because the rule no longer exists. The Second Amendment organization case in Texas was just dismissed with prejudice, meaning it cannot be refiled. That leaves this one remaining case as potentially the last line of defense against future pistol brace restrictions. The plaintiffs are fighting for a permanent injunction that would block the ATF from using its legal theory to regulate braced pistols going forward. The DOJ is arguing the case should be dismissed because there's no active rule to challenge. The court's decision here could determine whether pistol brace freedom is truly secured or whether it's just on temporary hold until the next administration decides to pick up where the last one left off. What happens next in this case will set the tone for how the ATF approaches firearm regulations for years to come. Will courts have the power to shut down threatening legal interpretations before they become active enforcement? Or will agencies be allowed to keep these interpretations in their back pocket, ready to deploy whenever the political winds shift? The celebration over the pistol brace rule being struck down was premature for a lot of people. The real fight, the fight over whether this can ever come back, is still very much ongoing. And right now it all comes down to one case and one court's decision about whether the ATF gets to keep its backup plan intact. This situation is developing, and as more information comes out, the implications will become clearer. For now, gun owners should understand that the threat hasn't been eliminated, it's just been paused. And whether that pause becomes permanent depends entirely on what happens in this final critical legal battle. That's it for today, folks. See you in the next video.